Legally Speaking, with me, Tarun Nangia. Today, we are going to discuss the issues of data privacy and also the bill that is going to be presented to Parliament. Of course, we all know that the Joint Parliamentary Committee has presented its report on specifically on the issue of privacy. That also we will delve into today. Being such an important issue, we thought that we must discuss it till it is passed in Parliament, because I think there are concerns that need to be addressed. There have been dissenting notes actually also in the Parliamentary Committee report as far as collection of non-personal data and storage of data and these kind of issues are concerned. We'll bring that up in the course of the discussion today. May I introduce you to my panel on this very important issue. I have with me Gayatri Roy. She's partner with Saraf and Partners and looks into these areas. I have with me Apar Gupta. He is Executive Director of the Internet Freedom Foundation and takes up cases on data privacy. I have with me Advocate Khushbu Jain, who's an advocate practicing in Bombay High Court and also at the Supreme Court of India. She also takes up cases regarding to privacy and data, in a sense, usage. May I request Gayatri to lay the ground of the discussion today with regards to the bill and where are we headed as far as the data usage issue and also the issue of privacy is concerned?
So I think, Tarun, I think we've gone beyond that time where anyone had to discuss whether we need a data protection law, which is more robust than what we have today. I think that's clearly the case. And this law may be a long time coming in that sense. I think the debate today is what is the form it should take in certain, particularly with respect to, I think, data localization is one of the areas. What would be critical personal data is one of those questions, that is of concern to service providers, is what I would, I put it as. But I think there's been a tangential, there's been the JPC has gone on a tangent, which I think is going to be a big concern, and that is what is going to be the position of the social media platform under the data protection bill. I don't believe that the data protection bill, even as placed before the Parliament originally in 2019, even contemplated content-related liability for the social media intermediary. And the fact that the JPC is now using in its recommendations indicating that the PDP bill should be looked at to introduce provisions, I think may be an area of concern. But again, one needs to see how those clauses actually drafted. But currently, what the JPC is proposing as far as social media intermediaries are concerned is very different from what is currently provided for in the bill. So that, that's, I think, an important aspect that we should discuss, over the show. That would be my that would be my first point to observe.
Okay, point well taken. I'll go to Apar Gupta. Apar, you've written some articles on the subject leading up to when the bill was being discussed in the nascent stages. Could you share with us your initial views on this issue?
So the bill is a culmination of years of work, and it's gone through several processes. Now, earlier versions of the data protection bill looked at two focal areas of regulation. One was data protection, in which consent-based regulation is needed whenever personal data is gathered from an individual. But the earlier bills prior to this version also dealt with surveillance reform, which is a core issue given that people are also fearful of how the government surveils them. And today technology is cheap enough that it can be done in very large respects. So you do need some regulations there. So the ambit of the bill at this present point in time is much more restricted to data collection, which is on the basis of consent by itself, right? So it's not dealing with instances of Pegasus, interception, surveillance, etc. So it has a much more limited ambit. That's one thing I wanted to indicate. The second thing I wanted to indicate is that one of the principal collectors of our personal data for most citizens in India is the government by itself. And here there have been press reports that the JPC has watered down certain provisions with respect to the application of bill with respect to public authorities and state functionaries, where there are two principal exemptions. The first is the non-consensual collection and processing of data, that the state essentially does not need to seek consent in cases of necessity. And the second is the central government's power to notify specific departments or public offices which can be exempted from the application of the bill itself. I'll get into this later, but essentially this is posing a very worrying question mark on the efficacy of the bill, especially with respect to its application with government departments itself. For instance, it would put us to a disadvantage if the bill is not applicable and the protections can't be availed for data breaches by public departments and state governments.
Data breach by public departments and also PSUs, because they also collect a lot of data. But I'll move ahead. Advocate Khushbu Jain, your opening comments on today's topic.
Much has been covered by Gayatri and Apar as to what what we are looking ahead, whereas the current the pending data protection bill is concerned. But one good aspect which I could understand from the bill is that till now there had been no protection, whereas consumers were concerned in case of data breach. We did have right to privacy. We did have that was incorporated as a fundamental right, but there was no protection for consumers in case the breaches happened. Now this bill is having an attempt to make that right by making it mandatory for companies to report the breach to the supervisory authority within 72 hours. This is one good aspect which I feel, and we are looking into some penalties also in that aspect. Also keeping in mind that data localization norm, yes, I think that's another good thing to talk about whereas bill is concerned, which makes it in a way mandatory to have sensitive and critical data in India, and also there is a slight provision which I still have a problem with regard to data localization. As to one is to understand what do we understand by data localization. Are we thinking of keeping data in India and a mirror copy can go outside India, or are we restricting ourselves completely? The way RBI circular was that the entire sensitive data or critical data has to be in India and it cannot have a copy outside. Now another aspect comes over here is the observation. How do you implement this? How do you impose this? So that's another question which one has to keep in mind. Now, another thing we talk about here is, yes, the social media aspect, which was being covered, that the bill do talk about, covering social media, that they should be at par with publisher, and, those same applications, same rules and regulations should apply on them. So yes, these are the three aspects, I think, which are there, which one has to look into, and the high penalties which we are looking as compared to what GDPR has. I think the same kind of penalty we are looking here in the new data protection bill, which we are looking into, I think. And also commenting on the part of, yes, I do want to discuss the aspect, whereas the ambiguity space which Apar was talking about, whereas whereas government is there is a clause which specifically and the entire UN CRAW from past a week, which was there in Parliament, talking about the agencies which have been the government agencies which will have been exempted from from the provisions. So that's something I think has to be discussed and touch upon in today's discussion.
Okay. Point well taken. I'll go to Gayatri here. The JPC report talks about the usage of and collection of non-personal data as with regards to what Google collects from our traveling routes, or on a minute-to-minute basis, as also data which is personal. Now, how will we segregate this data, and also the storage? Should all data be used in a sense stored in India, or where are we headed? Can you clarify it for the audience?
So, as far as the PDP Bill 2019 is concerned, it makes a distinction between non-personal data and personal data. It defines it rather neatly to say non-personal is everything that's not personal. So there is a clear distinction. And personal data is the data to which all of the protections under the PDP apply. The sole purpose of non-personal data is to allow the government to direct commercial entities to provide it with non-personal data. But I think the concern here really is that a lot of this non-personal data could be either innovation proprietary to the companies. That would be one. Another could just be business intelligence, that is very, very important. And why should the government be able to simply direct handing over of such data sets or non-personal data to the government? Usually the government pays for something that it requires. And in this relation, I find this provision to be entirely unique in that sense that the government just says, hand over something to me, and what's the nexus with the object, etc. So that is certainly going to, if it goes in its current form, I would expect it's going to be a ground for challenge, and quite possibly on the basis that if the government needs something, it should pay for it. Like it has a tender for any other input service, it should be paying for this rather than the law stepping in and saying that I can direct you to hand it over. So I think that's one area. On the localization bit is a different issue, and I can come to it later. I think Apar wants to say something, so I was going to hand it over to him maybe. But on the localization is a slightly different issue, which I would, come to subsequently. If you want me to handle it now, I'm happy to speak about it right away. So I think on the localization, again, it's a policy issue, whether we want the data localized here. I think the mechanism being suggested is that as far as sensitive personal data is concerned, it can be transferred outside, but a copy maintained here, processing happening here, subject to certain limitations, one of them being that the data principal consents. And then there are certain other processes which may be time consuming and operationally difficult, right? As far as critical personal data is concerned, now that is not to be allowed to go outside at all, and all of the processing to take place. But today we don't know what critical personal data is, and the government has the power to notify it. If you read it, I would say if you want on interpretation basis, if you ask me, a lawyer could interpret it to give it some meaning and say that there are certain guidelines, but I would expect that the government would use this power after doing an impact assessment, rather than, because it could have the effect of driving out certain businesses, or certain businesses may decide that no longer is feasible for them to stay here if all of the operations have to be undertaken here. So, in that sense, it's a good thing that critical personal data has not been identified and the government is going to notify it. So one would expect that there will be an impact assessment before they did that. But the concern is that it's an unbridled discretion to notify, critical data.
I'll go to Apar Gupta at this point. Apar, would you want to take on from what Gayatri said? And of course, on the issue usage of non-personal data, will you also compel companies to store that in India?
So first, let me just deal with it a little much more conceptually, and then I'll come to the specifics. If you've seen the creation of any regulatory body in India, and I think Khushbu hinted at it, it's gone through a process of establishment, potential exploration of jurisdictional ambit and boundary, legal challenge, amendment. And sometimes these cycles have repeated themselves. So if you look at the Competition Commission and the enforcement of the Competition Act, you look at the telecom regulator, the TRAI and the TDSAT, all these systems have developed through all the much more recent IBC. If you look at it, the law is said, you discover through experience that some parts of it conflict with either constitutional rights, or it shows arbitrary legislative policy, it's struck down, or it's reconsidered, it's amended. So we are taking a good first step, and there is a wide ambit of regulation we're stepping in. Now, with respect to the issues which have been highlighted, firstly, with respect to non-personal data, there was a separate committee set by the Ministry of Electronics and IT, headed by Krish Gopalakrishnan, who's I think the executive chairperson at Infosys, and there was a large industry participation from Indian startups. The primary justification, and I explained this economic rationale, is that large anonymized data sets, for instance, it's been reasoned map activity with respect to vehicular traffic flows, can help civic transport, but also can help other startups from weaning dependence away from large platforms which have these sets over years in the sophistication. So they also have a level playing field. I think these are not issues of data protection, but properly issues of competition, whether there is a level playing field, right? And even if there's a public utility argument to it, I think competition law can take care of it. So it's somewhat peculiar in India. We're looking at non-personal data from the point of, from the lens of regulation from a data protection law. With respect to data localization by itself, it's being articulated almost in a way in which it's a strategic resource where data, if it is stored within a country, it is like storing gold. It's like storing oil, right? And server capacity, etc., will also encourage greater degrees of innovation. So I do not know whether the economic literature actually supports these kind of policy prescriptions. And my final comment on this is a variance from existing data protection standards, because the reasoning behind data localization quite often is that our citizens should get the same amount of data protection under our national laws as they get it from global service providers who may have their servers elsewhere, right? But the model which has been followed, for instance, under the GDPR, or if you look at a comparative aspect of modern data protection laws, is an adequacy requirement. Essentially, the country in which the company and the service provider or the service is, and the country and the other country in which the recipient of that service is, should have equal levels of legal protection based on the laws in either country, domestic laws. So that works rather well, rather than enforcing a very strict boundary and saying that data will not leave this country itself. And I think there's incredible amounts of ambiguity as per the phrasing of the bill when it was introduced in Parliament before it was referred to the JPC. I look forward to the report. I hope there's some guiding criteria over and above the central government having absolute discretion in the respect of notifying mandatory data localization of critical personal data.
Khushbu, I'm going to ask you a layman's question on the bill. There is a lot of keenness to know that a lot of these apps which people download via app stores or via other platforms, they take away a lot of your data. What is going to be the status of that data? Because see, in common parlance, a lot of people are interested in, the apps, the social media apps that they use, the consumer facing apps where you're buying a product and you actually part with a lot of data in that process. Can you share with the viewers, the common viewer, how will this bill benefit him or her?
See, one good aspect which the bill covers is right to be forgotten. The second aspect is, I'll come on the right to be forgotten later, but the aspect where is, the consent and explicit consent. So depending on the kind of data which these apps or these platforms take from you, which category they fall into. They are into category of critical data, they are into the category of sensitive data or personal data. Depending on that, the kind of consent you have to give explicit consent. So we have always faced the aspect, whenever the breach happens, let's say today the breach happens, how do you understand where the breach has happened and to whom do I hold it accountable? In the presence of right to privacy, also in the presence of these sensitive SDPR rules which we had, how do I enforce it? So the problem comes is when we give, the contract is between the two parties. Now, the moment they share it with a third party, I'm not aware who are the third party, who are the details over there, what kind of data are you sharing with the third party, what that third party is doing with your data, whereas that third party is concerned. So there, this bill clearly provides that if your certain aspect is a part of sensitive data, you have to take explicit consent. Anytime you share it with a third party, you have to again and again take consent from me in that. This is one. The second is, in case the bill also provides for that, okay, in the scenario that these apps, the scenario was if you do not agree with the terms and conditions, you can't use their services. No. In case the direct nexus is, with the kind of data they're collecting doesn't have a direct nexus to the kind of services they're providing. Like, for example, for an Uber app, if you don't allow location, it would be difficult for them to run. So apart from that nexus, which has direct nexus with their business, whatever the extra information or data they're asking you for, if you do not allow, should not have any changes in you using the service and the other user who's using your services. They cannot deny you services. This is second. The third aspect also comes as to data collection and information, that now I can ask these data fiduciaries that what kind of data are you taking from me? Can I have a copy of that data? What exactly is the data which is available with you, whereas I'm concerned? You have an option of data correction over there. Those 9 principles of privacy. So it's trying to imbibe that into the bill and enforceability of those 9 principles. Now, another aspect that comes is, in case I want to exercise my right to be forgotten, yes, you can exercise your right to be forgotten. I'm still unclear about the part that what happens with the past data of mine, but yes, you do have a right to correct. So whatever the information they have, you feel it's not the correct information, I want some correction to happen into that. Yes, you can recall your data. A right to be forgotten is there, but in today's scenario, when your data has already been lying in multiple data centers and locations, what exactly, how many times it has multiplied, it has gone to how many different entities, third parties, how it will be enforced, whereas from today, yes, it can, but how will it be enforced? Whatever the data has already been collected. And let's not forget the aspect of facial recognition of Facebook, where Facebook nicely came up and said that from now on, I'm recalling my option of facial recognition. So imagine it already had. So can I ask them that what exactly you had? Can I recall? Can I, is there a provision of right to be forgotten to that? So yes.
Taking on from what Khushbu said, again, a question for our common viewers. Gayatri, if you happen to use an iPhone, you will get a pop-up again and again, which speaks that this app has been collecting your location data. And then you realize the app has got nothing to do with the location. I mean, it doesn't need my location, but the app collects. And there are many other things that this app has been tracking this kind of data, and iPhone will says, will you, do you want to give it, accept or deny? So many times then people have that option. But for example, on a Google Play Store or Android, I don't think that pop-up comes. As far as a common man who's watching a program, a mobile phone user is concerned, where does he stand if this bill is passed? I mean, does it ensure more privacy for him? Does it give him an option of recalling his data? Could you share this with the audience?
From a law perspective, I'd agree with Khushbu that there's a lot more control that the user has. Whether he opts for that control or not, in practice, needs to be seen. But there's a lot more control, and the service provider would have to put in systems where he asks for an opt-in rather than an opt-out. So that is something which would certainly make changes, will bring about changes. I think if you notice today, even if we go online on any website in view of the GDPR, etc., there are very clear notifications that they're using cookies. Do we accept cookies? That's across the board. Now you're going to see those kind of notifications. Whether our users are savvy enough to recognize this and see what the implications of saying a yes versus a no is. Again, it may take some time. There may be many that are savvy enough. There may be those that are not. But I think it's a step in the right direction to give the user control over his data, because there's too much of data that's being collected. That's a fact of the matter, that our interconnectedness means that there's a lot of data that's going to be collected, and it's good for permission to be taken and for the right to be able to ask, what is it about me that you are collecting?
One final question to you, Gayatri, would be the status of social media intermediaries. How will they be treated after this bill is passed?
That's where, Tarun, I think I have quite a strong reaction there to what happened with the JPC. But again, one doesn't want to. It is speculation till we see the report. So, I would definitely caution that this could be speculation. But if what the JPC wants to do is to render them liable as publishers, then you're in effect not treating them as an intermediary. And I think there's no answer to it to say that those social media platforms that are not intermediaries will be liable as publishers. You're just basically changing the burden. Today, a social media platform, there's a presumption that it's an intermediary. And, in the safe harbor rules are robust enough in the event that you actually, you're selecting the receiver of a message, which is known to, happen. If there's been criticism of it, that you're selecting the receiver of a message, you're targeting certain messages to certain receivers, etc., then the safe harbor under the IT Act will not be available. So where is the need to turn that system on its head, and render them liable as publishers? Because even under 79, if I failed, if I didn't qualify for safe harbor under Section 79, my liability need not necessarily be that of a publisher. Here, by deeming fiction of law, you're going to say you're going to be liable as a publisher, even though I didn't choose that content. I may not have had editorial control over it. So that, I think, is a matter. It seems to be a rather strong. I think that's the one major part where the JPC seem to have recommendations. And like I said, it could be just speculation right now, and one should maybe wait and see this aspect of it, because it certainly is going beyond. It has nothing to do with the data principle at this point. Okay. When you discuss what's happening, it's not related to
thanks,
protection.
We may need to revisit this issue in a couple of weeks from now. There is some amount of confusion on the topic. I myself spoke to a few people involved in the lawmaking process. They also needed a deeper understanding, they said, because I think data is a subject which a lot of people read about, but very few people understand the implications of data usage and collection by corporations. That's something that we need to talk more about. I mean, as and when the bill is presented in Parliament, maybe go clause by clause. And of course, I think Apar, Gayatri and Khushbu will be kind enough to come again and share it with our viewers if they have any objections or, if they have any inputs to share. But I would like to thank all three of you for sparing time and joining me today on Legally Speaking. Thank you, viewers, for joining us. Thank you so much.
Thank you for asking us.
Thank you so much, Tarun.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.